Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been providing you with periodic updates regarding the federal lawsuit styled as Scofield versus Guillard. This is a defamation case which was originally filed in December of 2022, several days before Mr. Coberger's arrest at the end of that month in Pennsylvania, in the matter styled as Idaho versus Coberger. Recently, the state of Idaho also referenced Scofield versus Guillard in a filing that both parties, state and defense, were court ordered to submit. This is to provide you with an update of what's going on with the case right now as it relates to a pretrial filing that the defendant, Ms. Guillard, filed earlier this month. Specifically on September 2nd, 2025. It's a motion in limine. And it is entitled Defendant Ashley Guillard's Rule 702, Motion in Limine to exclude expert testimony and evidence of Rebecca Bon, M.A., and Rebecca J. Talent, document number 102, docket entry 102. She writes here, Defendant Ashley Guillard respectfully moves the court to exclude the expert testimony of Rebecca Bon, M.A., and Rebecca J. Talent due to the complete failure of each witness to meet the required elements of Rule 702 and applicable case law. This motion is supported by the attached memorandum in support, the attached exhibits, Federal Rule of Evidence Rule 702, state laws and federal laws. And this is dated September 2nd, 2025, signed Ashley J. Guillard, pro se litigant, page number 2. Of this document is its certificate of service, whereby Ms. Guillard, the defendant, certifies that on September 2nd that she served a copy of the foregoing upon Corey M. Carone and Wendy J. Olson. A few points that I would like to raise at this time, ladies and gentlemen. This is the first of 2 episodes that we're going to be providing on the motion in limine to seek a pretrial ruling. That's what a motion in limine is. Motion is an application for a court order. In limine means pretrial. The trial of this matter is set to occur in February of 2026. Coincidentally, in Boise, not the state courthouse where Idaho versus Coberger was pending, but in the federal courthouse in Boise. This was originally supposed to have been with trial at the federal courthouse in Moscow, but the federal courthouse in Moscow, as the court explained when rendering the pretrial and trial order as it did in August of 2025, has closed. With the Moscow courthouse closed, the court had originally set the trial to occur in Coeur d'Alene, and then it's been reset now to occur in Boise, the same city where the trial that never happened in Idaho versus Coberger was supposed to happen. Secondly, there is another connection between the state case of Idaho versus Coberger and this federal case, the defamation action. In addition to alleging that she was defamed, Ms. Scofield, by Ms. Guillard, referring to her as having participated in the unalivings at 1122 King Road as set forth in the complaint. Her counsel, Wendy J. Olson, who was lead counsel in the federal case, also represented the media several times and in several appearances in Idaho versus Coberger, most recently in July of 2025 in the media's unsuccessful attempt to have all of the documents under seal unsealed, but in their successful attempt to set aside the non-dissemination, aka gag order. And Ms. Olson had appeared before Judge Hippler in January of 2025, and then back in 2023 when this case was in Latah County, and also made appearances before the Idaho Supreme Court with respect to that then pending non-dissemination order. And then also Ms. Guillard filed a document that was stricken by Judge Hippler in May of 2025, seeking to obtain documentation that was under seal in the case on the grounds that she was not a party to the action, and referring her essentially to file a public records request. With respect to this in limine motion, what Ms. Guillard is attempting to do, as it indicates here, is under the Federal Rule of Evidence, FRE 702. It's federal court, so federal rules and rules of evidence, civil procedure and rules of evidence apply, not state rules. And what she is seeking in this motion is to have the court render an order that the two proposed experts on behalf of the plaintiff do not meet the standard under Rule 702 and the applicable case law interpreting what a proposed expert must meet in order to be able to come before a jury, as Ms. Scofield is attempting to have her two witnesses presumably do at the forthcoming jury trial in Scofield versus Guillard. In the second part of this two-part episode, we're going to go over the memorandum of law. It's 11 pages long, it's detailed, it has both the factual background that Ms. Guillard is bringing forward, alleging that grounds exist to have these two proposed experts stricken, and then also the legal authority that she is citing. So please stay tuned for that presentation. Please be sure to subscribe to the channel and hit the notifications button so that you will receive notifications when we come forward and publish part 2 of this two-part series. And also, if you have not already done so and are interested in the Idaho4 defamation case as it prepares to go to trial, please be sure to review some of our prior content and look at the federal filings that have been filed in this case for further details and information. The defense's motion in limine is now pending. Ms. Scofield's response is due on the 23rd of this month. We will, of course, provide you with an update once that is filed. If you have any comments, any opinions, any thoughts regarding this matter, please be sure to leave them here. And until next time, this is Kathy. Thank you very much for joining us here today.